Note: the following audio-visual does not replace the CCRs filed with the county clerk. Company addresses have been updated and dates have changed to reflect current IRS information. Declaration of covenants, conditions and restrictions for the Lakes of Delta Bluffs, planned development. Phase X, Area I Plat Book 103, pages 18-19. This declaration is made this 18th day of January, 2007, by Ascent Investments, LLC, a Mississippi limited liability company, hereinafter referred to as declarant. Witness it. Whereas, declarant is the owner of certain real property located in DeSoto County, state of Mississippi, and more particularly described in Exhibit A to this declaration. Whereas, it is the intention of declarant to subdivide said property described in Exhibit A into a planned development, the development, and to convey interests therein by appropriate deeds, and to impose thereon mutually beneficial restrictions under a general plan or scheme of improvements for the benefit of the entire development. Now, therefore, declarant hereby declares that the aforesaid property is held, and shall be held, conveyed, hypothecated, encumbered, leased, rented, occupied and improved subject to the following limitations, restrictions, covenants and conditions, all of which are established and agreed upon for the purpose of enhancing and perfecting the value and attractiveness of said property, and every part thereof. All of the remedies, covenants, conditions, and restrictions shall run with the land, and shall be binding upon all parties having or acquiring any right, title or interest in the aforesaid property, or any part hereof, and shall be for the benefit of each owner of any portion of the aforesaid property, or any interest therein, and shall ensure to the benefit of and be binding upon the successor and interest of the owner thereof. 1. Definitions as used herein, and unless the context otherwise requires, the following terms shall mean. A. Articles means the articles of incorporation of the association. B. Assessment units shall mean the total number of lots subjected to this declaration. C. Association means Delta Bluffs Owners Association, Incorporated, a non-profit Mississippi corporation, consisting of all owners of lots in the development including declarant as long as any lot remains unsold. D. Board means the board of directors of the association. E. Board of directors means the board of directors of the association. F. Bylaws mean the bylaws of the association. G. Common area means any lot in the development which may be deeded at no cost to the association by the declarant. H. Development means the property described in Exhibit A and subsequent sections which may be added. I. Landscape and drainage easement means those areas designated on the recorded plats as such easements. J. Lot means any one of the lots shown on the official plat for Phase X, Area I, consecutively numbered from 258 to 289, and subsequent sections as may be added. K. Maintenance fund means the fund established for the specific purpose of depositing all assessments for the payment of operating expenses and establishing capital reserves for the development. L. Member means an owner. M. Mortgage means a mortgage or deed of trust covering all or any part of the development. N. Mortgagee or beneficiary means the holder of a mortgage or trust deed to all or any part of the development. O. Owner means the record owner, or owners if more than one, of a lot, including declarant as long as any lot remains unsold. P. Property means Phase X, Area I, all lake lot phases, Exhibit A, and all additional real estate added to this declaration. 2. Annexation of subsequent real estate in lots. A. Declarant may elect at any time to annex other real estate to become a part of the development and subject additional property to this declaration. It may do so unilaterally, without the necessity of concurrence by the owners of the real property then covered by this declaration, by executing and filing for official record an instrument subjecting such additional property to the terms of this declaration. 3. Common area. A. Declarant shall transfer and convey to the association, and the association shall accept declarant's fee interest in the common area. if any such real property may be subject to any or all of the following exceptions, liens and encumbrances. B. The lien of real property taxes and assessments that are not delinquent. C. Such easements and rights of way on, over or under all or any part thereof as may be reserved to declarant or granted to any owner for the use thereof in accordance with the provisions of this declaration. D. Such easements and rights of way on over or under all or any part thereof as may be reserved to declarant for access to real property contiguous to the common area. E. Such easements and rights of way on over or under any part thereof as may be reserved to declarant or granted to or for the benefit of the United States of America, the state of Mississippi, DeSoto County, any other political subdivision or public organization, or any public utility corporation for the purpose of constructing, erecting, operating and maintaining thereon, therein, and thereunder, at that time or at any time in the future, roads, streets, walks, driveways, parkways and park areas. B. Poles, wires and conduits for the transmission of electricity for heating, power, telephone, television and other purposes and for the necessary attachments in connection therewith. And C. Public and private sewers, sewage disposal systems, stormwater drains, land drains and pipes, water systems, sprinkling systems, water, heating and gas lines or pipes and any and all equipment in connection therewith. F. The obligations imposed, directly or indirectly, by virtue of any statute, law, ordinance, resolution or regulation of the United States of America, the state of Mississippi or any other political subdivision or public organization having jurisdiction over such property, or by virtue of any organization or body politic created pursuant to any statute, law, ordinance or regulation, and G. Any other lien, encumbrance or defect of title of any kind whatsoever, other than of the type that would at any time or from time to time create a lien upon such property to secure an obligation to pay money, that would not materially or actually prejudice owners in their use and enjoyment of such property. 4. Landscape and drainage easements, buffer areas. Declarant or the association may make improvements within designated easements. The association will maintain all landscape improvements and the area included in the drainage easement. No lot owner may modify, change or alter any improvement within the landscape and drainage easements. In addition, no lot owner may modify any drainage swales or landscape buffers, and shall maintain such swabs or buffer areas on their lot. 5. Members, each owner, by virtue of being an owner, shall be a member of the association. The rights, duties, privileges and obligations of an owner as a member of the association shall be those set forth, and shall be exercised and imposed in accordance with this declaration and the association's articles and bylaws. The association shall accept all owners as members of the association. An owner who is delinquent in his obligations to the association shall not be entitled to vote as a member of the association during the term of such delinquency, but he shall at all times remain a member of the association. No owner may withdraw from membership in the association. A. Authority of members, in addition to any other powers and authority provided in this declaration. Beginning in the third fiscal year of the association, the members of the association shall have the following authority. B. To elect a board of directors. C. To effect necessary amendments to this declaration, in the manner provided in paragraph 20, amendment, hereof. D. To recall any member of the board, with or without cause being shown, by affirmative vote of the majority of the members present, at a duly noticed meeting of the association at which a quorum is present. E. To subject any action taken by the board to levy any assessment greater than 115% of the prior year assessments, as provided in paragraph 7 of this declaration, to review by the association. Such review may be had only upon petition to the board signed by the owners of at least 1/5, 1/5 of the lots and delivered to the board within 15 days from the date of notice of any assessment. Upon receipt of such petition, the board shall call a meeting of the association as promptly as practical, And, in the event that a majority of the members of the association present at such meeting at which a quorum is present vote to nullify the assessment, such vote shall be binding upon the board and the assessment shall be limited to 115% of the prior year annual assessments. F. Meetings. An organizational meeting shall be held at any time and place to be designated by declarant, reasonably near the first sale of a lot in the development. 6. Beginning in the first fiscal year, annual meetings of the association shall be held. The sole purpose of the annual meeting shall be to hold elections for members of the board whose terms are expiring. The time and place of each annual meeting of the association shall be determined by the board so long as it is no longer than 90 days after the end of the fiscal year and all owners are given at least 30 days written notice prior to the meeting date. A. At all meetings of the association, 15% of the then record members shall constitute a quorum. At all meetings of the association each lot shall be entitled to one vote. Every member entitled to vote at any election of the board is entitled to one vote for each of the directors to be elected, multiplied by the number of votes to which his lot or lots are entitled. Where a lot is held of record by two or more persons jointly or as tenants in common or as a partnership, or otherwise, said members shall designate by written notice addressed to and filed with the board the person from among their number who shall vote for the lot at all meetings of the association. Such designation shall be revocable at any time by written notice filed with the board signed at least a majority of the persons entitled so to act. The rights of a record member of any lot and such powers of designation and revocation may be exercised by the guardian of the record member's estate or by his conservator, or in the case of a minor having no guardian, by the parent entitled to this custody, or during the administration of any record member's estate by his executor or administrator where the latter's interest in said property is subject to administration in his estate. Where no designation is made by the multiple owners of a lot, the association shall accept the representation of one of the multiple owners that he has the right to cast the vote for such lot unless another multiple owner questions that right, in which event neither multiple owner shall have the right to cast the vote relating to such lot. An owner may grant another the proxy to cast his vote by a writing delivered to the association. The declarant is entitled to 3 votes for each lot owned by it. B. If any meeting of the association cannot be held because a quorum is not present, said meeting may be adjourned to a time not less than 10 days, not more than 30 days later. Written notice of such adjournment and the date and place of the continued meeting shall be given to each owner no later than 72 hours following the date of adjournment. At any such continued meeting, the total number of members present shall constitute a quorum, regardless of the percentage of the total members of the association which is present. C. Beginning in the 3rd fiscal year, owners representing at least 20% of the entire membership in the association may at any time request in writing that the board call a special meeting of the members of the association at the earliest practicable date. Such written request shall state the matter or matters that the members desire to discuss at such meeting. 7. Authority of association. The association, for the benefit of the lots and owners thereof and acting through its board of directors and officers elected by such board, shall enforce the provisions hereof and shall have the following powers and duties, to wit, a. To conduct, manage and control the affairs of the association and the development, and to make such rules and regulations therefore not inconsistent with the law or this declaration as is deemed in the best interest of the owners. B. To appoint an agent or manager for the development, and to delegate of its powers to such agent or manager as may be required for its proper functioning, provided, however, that an agent or manager selected prior to the first annual meeting of the association, after the initial organizational meeting, shall be employed to manage only until the first annual election, at which time the continuance of the same or the selection of another agent or manager shall be determined by the board. C. To contract and pay for out of the maintenance fund hereinafter provided the following: I. Water, sewer, garbage, electrical, telephone, gas and other necessary utility services for the common area. II. Workmen's compensation insurance to the extent necessary to comply with any applicable laws. III. Compensation for such agent or manager of the development, and for other workmen and personnel as may be employed by the association. IV. Legal and accounting fees for services necessary or proper in the operation of the development and association or enforcement of the restrictions and governance herein contained. V. Charges for the maintenance and repair of the common area, but not including lots, which the respective owner shall maintain. Charges for electrical and utility bills relating to street lighting provided by Coahoma Electric Company for Phase X, Area I, and for lighting on entrance to subdivision on Goodman Road and Delta Bluffs Parkway and for such equipment as the board shall determine is necessary or desirable, and the association shall have the exclusive right and duty to acquire and maintain the same. V. Expenses for any other materials, supplies, labor, services, maintenance, or repairs that the association is required to secure or pay for pursuant to the terms of this declaration, or by a law or that, in its opinion, shall be necessary or desirable for the development or the enforcement of these restrictions. VI. Any amount necessary to discharge any lien or encumbrance levied against the entire development or any part thereof that may, in the opinion of the board, constitute a lien against the common area, rather than merely against the interest therein of a particular owner or owners, except that where one or more owners are responsible for the existence of such lien, they shall be jointly and severally liable for the cost of discharging it, VIE. Expenses for maintenance and repair of any lot if such maintenance and repair is necessary, in the opinion of the board to protect and preserve the common area, and the owner or owners of said lot have failed or refused to perform said maintenance or repair within a reasonable time after written notice of the necessity of said maintenance or repair is delivered, personally or by certified mail to said owner or owners, the association, its agents, servants and employees, are hereby given the right and license to enter upon and in any lot for the purpose of making and effecting such maintenance or repair, provided that the association shall levy a special assessment against the owner or owners of any such lot to pay for the costs or expenses arising out of or incident to said maintenance and repair, and assessment therefore. Ikes. Taxes and special assessments that are or would become a lien on the common area, and X. Maintenance of improvements in landscape and drainage easements, and repair of any drainage easement in the development for which DeSoto County has declined to accept such responsibility, XI. Insurance policy or policies insuring the association board and each and all of the owners against any liability to the public or to the owners or any other person resulting from or incident to the ownership, management and use of the common area by the board, owners, their invitees and tenants and members of the public, the liability limits under which insurance shall not be less than $500,000 for the total personal injury from any one accident. $200,000 for personal injury to one person, $50,000 for total medical payment for each accident, and $50,000 for property damage, such limits to be reviewed at least annually by the board and increased in its discretion. The board may also obtain such errors and omissions insurance or other insurance as it deems advisable, insuring the board and each member thereof against any liability for any act or omission in carrying out their obligation hereunder or resulting from their membership on the board or any committee thereof. If additional insurance is required due to extra hazardous use made of any lot or because of improvements to any lot installed by its owner, which increases the premiums for the required amount of coverage, the cost thereof shall be assessed to the owner of such lot. In order to facilitate the provisions for maintenance of adequate and proper insurance, it is contemplated that declarant may contract for insurance coverage covering the common area as contemplated by this paragraph prior to or concurrently with the first sale or sales of lots in connection with the financing of such sales, and any obligations or commitments for the payment of premiums or expenses otherwise incurred by declarant under any such policy or coverage. Whether or not the same is also a personal obligation of the purchaser or purchasers of any lot, shall become an obligation of the association and shall be paid for out of the maintenance fund as provided herein. Any owner may purchase such liability insurance as he may deem advisable for his own account and at his own expense, except that the carrying of any insurance individually by an owner shall not relieve him of the obligation to pay such portion of assessments as may be made from time to time for purpose of paying premiums or other charges on liability insurance carried or contracted for by the association for the benefit of the entire development. D. The agents of the association may enter any lot when necessary in the opinion of such person or persons in connection with any maintenance or construction for which the board is responsible. Such entry shall be made with as little inconvenience to the owner as practicable, and any damage to the lot caused thereby shall be repaired by the association at the expense of its maintenance fund. There is hereby specially reserved an easement for ingress and egress to each lot and in, over, and upon each lot for such purposes which shall be exercised by or upon the authority of the association. E. Nothing herein contained shall be construed to give the association authority to conduct a business within the development for profit on behalf of all of the owners, or any of them, without the concurrence by affirmative vote of a majority of the total membership. F. The association, by a majority vote of its board, may make expenditures in excess of 10% of its current annual budget only if the expenditure is included in the annual budget established by the board. This provision does not apply to any expenditure needed on an emergency basis. G. The association shall have the authority and power to enter into contracts with owners and lessees of lands adjoining or near the development, and with associations having powers with reference to said land similar to the powers held by the association. Any contracts so entered into may provide, among other things, for a joint installation, maintenance and repair of facilities benefiting the development and said other lands, and for the joint retainer of and use of maintenance, professional and management services for the joint discharge of any of the duties of each party to such contract to the extent that the duties so defined shall not be inconsistent with the duties, powers, and rights of the association as herein defined. Without limiting the generality of the foregoing listed contractual purposes, the association may also contract with such owners, lessees or associations to the end that enforcement of the liens established under paragraph 10, liens, hereof may be exercised by such other owners, lessees or associations in the event that the board should deem the same to be in the best interests of the association. H. The association shall have the duty to enforce the provisions of this declaration, including the duty to seek to enjoin any breach or threatened breach of any of the provisions hereof and to pay all costs of any such action or other enforcement procedure. 8. Board of Directors. The association shall be managed by a board of directors composed of 5 of the members or representatives of members, which hold title to lots, in a corporate or similar form. The board shall be elected by vote of the members at the annual meeting of owners. A. Meetings action by the board shall, unless otherwise stated herein or by law, be by written consent of the members of the board as permitted by Mississippi law or by majority vote of those present at meetings held for that purpose at which a quorum is present. B. Meetings of the board may be held at such time and location as shall be determined from time to time by a majority of the directors. The board shall in all events have an annual meeting. Notice of annual meetings shall be given to each director, personally or by mail, telephone or telegraph at least 7 days prior to the day named for such meeting unless such notice is waived. Such notice shall specify the date and hour of the meeting and the general nature of the business to be transacted. The first meeting of the board shall be open to all members except that the board may designate a part of each meeting as a closed executive session. With prior written approval by the board, a member may address the board at a meeting but shall not be entitled to vote. C. Notice of all meetings of the board shall be given, the same basis as to the board, to any member whose request to present an issue has been approved by the board. D. To constitute a quorum for the transaction of business by the board, it is necessary that at least three members of the board be present. Every act or decision done or made by a majority of the members present at a meeting duly held at which a quorum is present at the commencement of such meeting shall be regarded as the act of the board, except as otherwise provided herein. A quorum of the members of the board may adjourn any meeting of the board to meet again at a stated day and hour, provided, however, that in the absence of a quorum, a majority of the members present at any meeting of the board may adjourn from time to time until the time fixed for the next regular meeting. F. The transactions of any meeting of the board, however called and noticed or wherever held, shall be as valid as though had at a meeting duly held after regular call and notice, if a quorum be present, and if, either before or after the meeting, each of the directors not present signs a written waiver of notice, or a consent to holding such meeting, or approval of the minutes thereof. All such waivers, consents, or approvals shall be filed with the records of the board or made a part of the minutes of the meeting. G. A president of the association shall be elected at the first meeting of the board in every year. At the same time the following officers shall be elected by the board: vice president, treasurer, and secretary. The president shall preside at all meetings of the board, and all officers shall exercise and perform such other powers and duties as may from time to time be assigned to them by the board. If there shall occur during any year a vacancy in any office because of death, resignation, removal, disqualification, or other cause, the board shall elect a person to fill the vacancy so created, to serve in such capacity until the first regular meeting of the board in the following year. H. Special meetings of the board may be called by the president and must be called at the written request of 2/5, 2/5 of the votes of the board. Not less than 3 days written notice of the meeting shall be given personally or by mail, or telegraph, which notice shall state the time, place and purpose of the meeting. Written notice of the time of such meetings shall be given as provided above. I. The board may by at least 3 affirmative votes of the board members designate an executive committee and such other committee or committees as it may from time to time deem desirable to assist it in the management of the development. The committee may only make recommendations to the board, and the board may not delegate to any committee so created any of the powers of the authority of the board and the authority of the management of the development. 9. Maintenance fund assessments. A. Declarant shall pay all assessments for the first fiscal year. Thereafter, no later than 60 days prior to the beginning of each fiscal year, which until changed shall begin on October 1st, the fiscal year has been changed to begin January 1st, the board shall estimate the operating expenses, capital additions and additions to the reserve funds required for performance of its functions during such year, including a reasonable provision for contingencies, plus any cash disbursements in excess of the budget for the prior year, unless any surplus from the prior year's fund. Said estimated cash requirements shall be assessed to the owners, based on the formula in paragraph 7, no later than 30 days prior to the end of each fiscal year for the following year. In the second fiscal year such assessment will not exceed $10 per month for each owner. The board may provide for payment of such assessment on a monthly, quarterly, semi-annual or annual basis on such terms and conditions as determined by the board. If said estimated sum proves inadequate for any reason, including non-payment of any owner's assessment, the board may at any time levy a further assessment which shall be assessed to the owners in the same manner. Each owner shall be obligated and by accepting a deed to a lot shall be deemed to have agreed to pay assessments levied pursuant to this paragraph 7 to the association in installments commencing upon the first day of the fiscal year for which the assessment is made, provided, however, that any further assessments shall be paid at such times as may be designated by the board. Any installment of an assessment not paid by its due date shall be delinquent. B. Assessments shall be levied against the then owners in the manner provided in paragraph 7 hereof. Any such assessments charged or levied and that become payable with respect to a lot prior to the initial sale thereof by declarant shall be the obligation of declarant as the owner thereof. C. All funds collected hereunder, together with special assessments or charges as provided for in other sections of this declaration, shall be controlled by the association and shall constitute the maintenance fund referred to herein. D. Beginning in the third fiscal year, within 60 days after the end of each fiscal year, the board shall have prepared and made available to all owners a report with respect to the use of the maintenance fund for such year, which shall include a statement of cash income and expenditures and any amount remaining in such fund as at the end of such year. E. Beginning in the third fiscal year, the board shall divide the total estimated cash requirement by the total assessment units to determine the assessment to be paid by each owner. 10. Liens. A. The association shall have a continuing lien on the property of each owner as security for any sum owed by an owner to the association, including, without limitation, any assessment made by the association upon the property of an owner. The association may enforce said lien by appropriate action as permitted by the laws of the state of Mississippi. The owner shall pay reasonable attorney's fees and expenses in connection with the enforcement of such lien. Such lien and the right to enforce same are in addition to and not in substitution for any other rights and remedies that the association has hereunder or by law. Upon request and the payment of a reasonable fee, the association through an authorized representative, shall issue and deliver a certificate stating the amount, if any, owed by an owner to the association and secured by the aforesaid lien. Said certificate shall be conclusive as to the association in favor of all parties who rely thereon in good faith. 11. Mortgage protection notwithstanding all other provisions hereof. A. The liens authorized and created hereunder or by law upon the lot of any owner or owners shall be subject and subordinate to, and shall not affect the rights of the holder of any indebtedness secured by any recorded first mortgage, meaning a mortgage with a first priority over other mortgages, upon such lot made in good faith and for value, provided that after the foreclosure of any such mortgage the board shall have the authority to create, in the manner prescribed in paragraph 7, maintenance fund assessments, and 8, liens, hereof, a lien on the interest of the purchaser at such foreclosure sale to secure all assessments, whether regular or special levied hereunder for or payable during any period after the date of such foreclosure sale, which lien shall have the same effect and be enforced in the same manner as provided here in the case of other liens for unpaid assessments, and provided further that neither the purchaser at any such foreclosure sale, whether he be the mortgagee or beneficiary of the indebtedness secured by the first mortgage or otherwise, nor his grantee shall be or become liable to any extent for any portion of any assessment levied for or payable during any period subsequent to such sale to the extent that such assessment is for the purpose of covering or making up any deficiency in the maintenance fund resulting from the failure of any owner of any lot, which was the subject of any such foreclosure, to pay any assessment made prior to the date of such foreclosure sale, or deed, nor shall there be any such lien for any such portion of such assessment. B. An amendment to any part of this declaration shall not affect the rights of the mortgagee or beneficiary of any such mortgage recorded prior to recording of such amendment. C. Nothing in this declaration shall be construed as limiting in any way the rights of the mortgagee or beneficiary of any indebtedness secured by any recorded first mortgage on any lot hereunder to require from the mortgager or trustor thereunder such fire or other insurance as the mortgagee or beneficiary thereof in its sole discretion may require. 12. Taxes and assessments. Each owner shall execute such instruments and take such action as may reasonably be requested by the association to obtain a separate tax assessment of each lot. If any taxes and/or assessments may in the opinion of the association nevertheless be a lien on the entire development, they shall be paid by the association and shall be assessed by the association to the owners. Each owner shall be obligated to pay the taxes or assessments assessed by the county assessor or the city or any other municipal authority against his own lot and personal property. Each owner shall be obligated to pay an equal portion of any assessment by the association at least 30 days prior to delinquency of such tax or assessment by the county or city or any other municipal authority. Such board assessments shall be secured by the lien authorized to be created by paragraph 7, Liens, hereof. Each owner of a lot shall be obligated to pay any and all assessments for water, sewage, electricity, other utilities, taxes and other charges assessed individually against such lot. 13. Restrictions on use and occupancy of lots in Phase X, Area I. In addition to restrictions established by law and regulations that may from time to time be promulgated by the Association for Use of the Common Area, the restrictive covenants recorded in the Office of the Chancery Court of DeSoto County, Mississippi on Deed Book at page and attached herewith as Exhibit B and adopted for reference. 14. Repair and restoration. A. General notwithstanding the provisions for insurance contained herein, the association and the owners are under the obligation of maintenance, repair and restoration set forth as follows, provided, however, that all expenses to the extent covered by insurance shall be paid from such insurance proceeds. B. Owners. The owner of each lot shall maintain at his sole cost, and in the case of damage or destruction shall repair or restore the interior or exterior of his residence and his lot. All such repair or restoration shall be done substantially in accordance with the original plans and specifications. In the event an owner shall fail to properly maintain, repair or restore such areas after written demand from the association, then the association shall have the right to cause said work to be done with the cost thereof to be assessed against the owner as provided herein. C. Association. The association shall have the obligation to maintain at its expense, and in case of damage or destruction shall repair or restore at its expense, promptly after such damage or destruction occurs, the common area and all improvements thereon. D. Total destruction. If the improvements on the common area or within the landscape easements of the development are substantially or totally destroyed, the association shall restore the improvements as nearly as possible to their condition immediately prior to their destruction. 15. Audit beginning in the third fiscal year, any owner may at any time and at his own expense cause an audit or inspection to be made of the books and records of the board or any manager appointed by the board. The board shall prepare, or have prepared, an annual report of its activities, including a statement of income and expenditures, which shall be distributed to each owner. 16. Interpretation. The provisions of this declaration shall be liberally construed to effectuate its purpose of creating a uniform plan for the development and operation of the development. Failure to enforce any provision hereof shall not constitute a waiver of the right to subsequently enforce said provision or any other provision thereof. 17. Severance of interests. The component interest of a lot, including the ownership of the common area, and any easements granted, may not be severed, or separately sold, transferred or conveyed or subjected to any lien or encumbrance. Any sale, transfer or conveyance of or lien or encumbrance or claim against or affecting any lot shall cover and include the entire lot. 18. Partition. There shall be no judicial partition or subdivision of the common area or any lot, nor shall declarant or any person acquiring any interest in the development or any part thereof, seek any such judicial partition or subdivision thereof, provided, however, that if any lot shall be owned by two or more owners as tenants in common, or as joint tenants, nothing contained herein shall be deemed to prevent a judicial partition as between such owners so long as such judicial partition does not result in a physical partition. 19. Amendment. Except as otherwise expressly provided herein, the provisions of this document may be amended by an instrument in writing signed and acknowledged by 75% of the owners, which amendment shall be effective upon recording in the office of the Chancery Court Clerk of DeSoto County. For purposes of voting on a proposed amendment, declarant shall have 3 votes for each lot it owns. 20. Effective violations on lien. No breach of any of the terms or conditions of this declaration shall defeat or render invalid the lien of any mortgage made in good faith and for value. 21. Effectiveness of creation of development. The creation of the development on the property shall become effective upon the first conveyance by deed by declarant or a lot provided herein. Thereafter, and until the conveyance of all lots included in this development, it is understood that declarant shall for all purposes be the owner of the remaining lots until conveyed by declarant and shall have all the rights and benefits of the owner of such lots until conveyed by declarant to some other person or entity. 22. Invalidity of any provision. In the event any condition or restriction herein contained be held invalid or void by any court of competent jurisdiction, such invalidity or nullity shall in no way affect any other condition or restriction herein contained. 23. Binding effect of covenants, conditions and restrictions. Each owner and any successor in interest to said owner takes his right, title, interest and estates subject to all of the covenants, conditions and restrictions set forth in this declaration, and agrees to perform and be bound thereby. The covenants, conditions, restrictions and burdens imposed hereby constitute a general scheme for the benefit of each owner in the development, and will be imposed upon the first owner of any lot by express reference thereto in the deeds they receive from declarant. Said covenants, conditions and restrictions may be enforced by the board or by any owner or any combination of owners for any violation or threatened violation by proceedings at law or in equity against the person, violating or attempting to violate same, either to prevent such violation or to recover damages for such violation. Said covenants running with the land or equitable servitudes upon the land, as the case may be, and are intended to and shall be binding upon any and all future owners. 24. Duration. All of the limitations, restrictions, covenants, and conditions of this declaration shall continue and remain in full force and effect at all times with respect to the property, and each part thereof included within the development, to the owners and to the association, subject to the right to amend as provided for in paragraph 19, amendment, for a period of 25 years, provided, however, that unless within one year prior to the expiration of said 25-year period, there shall be recorded an instrument directing the termination of this declaration, signed by the owners of not less than 3/4 of the lots, the declaration for the association in effect immediately prior to the expiration date shall be continued automatically, without any further notice, for an additional period of 10 years and thereafter for successive periods of 10 years unless within one year prior to the expiration of any such period this declaration is terminated as herein provided. 25. Non-waiver breach. The waiver of a breach of any of the covenants, conditions and restrictions hereof shall not be construed as a waiver of any succeeding breach or violation thereof or of any other covenants, conditions or restrictions. 26. Attorney's fees. In the event that board or any owner or owners shall bring legal action against any other owner to enforce the terms, covenants, conditions and restrictions of this declaration, and they shall be the prevailing party in said lawsuit, the court shall award them reasonable attorney's fees and court costs. 27. Successors. This declaration shall be for the benefit of and be binding upon the heirs, legatees, executors, devisees, administrators, guardians, conservators, successors, purchasers, lessees, encumbrances, donees, grantees, mortgagees, lienors, and assigns of and from the owners in the development. Witness my signature, this the 18th day of January, 2007. Ascent Investments, LLC, H. E. Folk III. Chief Manager. Exhibit A. The Lakes of Delta Bluffs PUD. Phase X, Area I. Beginning at the southeast corner of Section 27, Township 1 South, Range 9 West, DeSoto County, Mississippi. Thence S89 degrees 4328 W, a distance of 872.55 feet to a point. Thence N00 degrees 2751 W, a distance of 3,687.20 feet to the true point of beginning for Phase X of the Lakes of Delta Bluffs PUD. Thence S55 degrees 5413 W, a distance of 196.53 feet to a point. Then says 66 degrees 2439 W, a distance of 260.31 feet to a point. Then says 57 degrees 1825 W, a distance of 143.00 feet to a point. Then send 32 degrees 4135 W, a distance of 37.07 feet to a point. Then says 57 degrees 1825 W, a distance of 193.00 feet to a point. Then send 32 degrees 4135 W, a distance of 431.20 feet to a point. Then send 21 degrees 2830 W, a distance of 78.57 feet to a point. Then send 17 degrees 0307 W, a distance of 80.26 feet to a point. Then send 9 degrees 4941 W, a distance of 1.85 feet to a point. Then send 76 degrees 3759 E, a distance of 143.00 feet to a point. Then surround a curve to the right with a radius of 525.00 feet, a chord length of 73.71 feet at a bearing of N9 degrees 2029 W, an arc distance of 73.77 feet to a point. Then send 84 degrees 4103 E, a distance of 178.00 feet to a point. Then says 52 degrees 5938 E, a distance of 22.18 feet to a point. Then says 10 degrees 4018 E, a distance of 46.98 feet to a point. Then says 21 degrees 0123 E, a distance of 57.82 feet to a point. Then says 30 degrees 3633 E, a distance of 61.89 feet to a point. Then says 32 degrees 4135 E, a distance of 17.00 feet to a point. Then send 57 degrees 1825 E, a distance of 70.00 feet to a point. Then send 18 degrees 0507 E, a distance of 16.92 feet to a point. Then send 0 degrees 0954 E, a distance of 282.70 feet to a point. Then send 25 degrees 3130 E, a distance of 366.42 feet to a point. Then send 35 degrees 0923 E, a distance of 73.53 feet to a point. Then says 90 degrees 0000 E, a distance of 55.99 feet to a point. Then says 33 degrees 4801 E, a distance of 109.26 feet to a point. Then says 9 degrees 2815 E, a distance of 71.89 feet to a point. Then says 19 degrees 4601 E, a distance of 219.22 feet to a point. Then says 3 degrees 1010 W, a distance of 125.43 feet to a point. Then says 16 degrees 3151 E, a distance of 124.11 feet to a point. Then says 32 degrees 3533 E, a distance of 155.65 feet to a point. Then says 12 degrees 5325 E, a distance of 77.10 feet to the point of beginning, containing 552,140.99 square feet, 12.68 acres, more or less. Lying in the northeast 1/4.